we'll start just with an overview of probate court, its jurisdictions. We'll talk about estate planning for the family. We'll talk about the civil commitment process. Affects all of our families, mental illness, alcohol, and drugs, and some trivia points to ponder. Remember, what are the 2 rules for judges' jokes? You go to a courtroom. Oh, let me see. Image is large and PowerPoint image is tiny in the corner. Can you see it okay, Jamie?
I'm afraid it's a lot smaller, at least from my view.
Can y'all see the PowerPoint? I don't know why. I think I've got.
Yes, I can see it says objectives.
Yeah. Is it real small or is it big?
No, it's full on my screen.
It's full on your screen?
Yes.
Okay, full on everybody's screen? Jamie, it's full on yours?
my screen.
Okay. Somebody might be on their phone. It might be small on that. Okay, I apologize for that. Anyway, if you're ever in a courtroom, remember only the judge tells the jokes. Rule 1, guess what rule 2 is?
Everyone laughs.
Right. No matter how bad the joke is, you got to laugh. Sincere laugh. You do well.
Okay.
Let's see if I can get it to go. Anyway, we'll talk about estate planning, touch on elder law, our probate court divisions, problem-solving courts, and estate administration. And try to cover a little bit for everybody in 1 hour.
Okay.
Any court, our court has a organizational chart. And if you're probating an estate, what you need to know, if you look over on the left-hand column, the estate division, we do about 2,200 estates. For you, each family, I've got it organized so one clerk helps the family from beginning to end. So if you look at the second line there, Tina Grooms has all estates ending in 0 and 5. Sharon has ending 1 and 6. Nicole 2 and 7, so forth. So once you get assigned an estate clerk, that clerk will help you from beginning to end. We find that works best for our families. If the clerk is out, lunch or vacation, the other clerks can step in there and help you. If you see all the way down, Jamie Robinson's our estate projects officer, and she's organizing this today. On our commitment division, you'll see the second column, conservatorship and guardianship. We have about 1,800 commitments we do a year. We'll talk more on that. Guardianship and conservatorship, one area that we want to avoid. And we can avoid the guardianship by the use of an adult healthcare power of attorney, a healthcare power of attorney. Avoid the conservatorship, which is of the money, by the use of a business or financial power of attorney or a trust. So we want to avoid guardianship and conservatorship by doing our estate planning. And we'll talk more on each of these. And then we have 4 problem-solving courts, giving people a second chance. And hopefully they can improve their lives. Very stringent programs, usually run about a year. They have to get drug screened, have to get a job, those types of things. Our happier side is marriage license. We do about 5,000 of those a year. And we have a love program that I'll tell you more about. And then we have a controller, and then we have law clerks there. Our probate court staff information, sort of like a little PowerPoint. Jamie's going to send all this out to you if you hadn't already. But anyway, you can call directly to your estate or GC clerk or any clerk you need to reach. We've got all of our personal numbers there. My numbers are there, my direct dial and my cell phone numbers. All of our clerks are set up to work from home, and that happened during the pandemic. So you can reach them directly without having to go through a switchboard operator. So this way it's quicker and hopefully easier for you. We're located down at the Four Corners of Law. If you come visit us, the mayor's office is on the bottom left. On the right there is the historic courthouse. Jamie's up there on the 3rd floor. If you look at the brick building on the bottom right, that's where I'm located. We didn't want a 7 or 8 story building, so we've got 2 different buildings because we are the holy city. The federal court's across the way, and then the highest law, the church, is located on the other corner. And it wasn't Riley or Ravenel, any of those are names. It was actually Robert Ripley that gave the name the Four Corners of Law. Then and now, it looks like the.
I think we lost the on
We lost
Uh-oh.
your audio, Judge Condon.
Oh, I lost my audio.
Goodbye.
Here,
It's
can you
back
hear me?
on now.
Back on now?
Yes.
Okay. I think we've paid the bill. Let me check, Jamie. We paid the bill? I don't know. Okay, can you hear me now?
Yes.
Yes.
Okay, good. Anyway, the State House used to be our courthouse, historic courthouse. Jamie's up on the 3rd floor in the middle of the building there. That's her window that you're looking on the back of her. And it was done by an Irish architect by the name of James Hoban. He did our courthouse. George Washington visited our city, liked the work he did. And he did the White House, which is behind him. And he modeled it after the Leinster House. So when you see the White House on the news, remember it's a Charleston architect that did our courthouse and the White House. We were over in Callan, Ireland, dedicating a monument. That's my son in the plaid pants. Our luggage didn't make it. He's not quite sure what to do with the Irish girl there, but we'll try to give Hoban the credit he deserves. We are in 2 buildings, I said. The estate division's on the 3rd floor. Our commitment division's on the right there on the 4th floor. All right, what's the highest basketball court in the land? A little trivia. NBA playoffs are on. What's the highest basketball court in the land? If we were in person, we'd have candy bars to give you. Jamie, remind me to bring candy bars for tomorrow, okay? What's the highest basketball court in the land?
I have no idea.
What's the highest court in the land?
Supreme Court?
Yeah, U.S. Supreme Court. And that is the answer. Guess what's above the chamber of the U.S. Supreme Court? There's a basketball gym. And I've made 2 out of 2 shots. You can't shoot while they're having arguments, but they do have a gym up there. That's a little trivia. Not even Michael Jordan scored that. This was my mentor and Jamie's. We both worked for Morris Rosen 30-some years ago, and he worked in that building there. Great Southern gentleman lawyer. He passed about 10 years ago, but he always treated everyone equally and with dignity and respect. And we hope to do that. Now let's talk about estate planning, why many of you came. And I've got another person joining us. Let's see. Okay, we got a Miss Coleman joining us. Let me see if she's joined. Is it Cerise?
Yes.
Yeah, good morning. We've started. I talked a little bit about probate court. We're now going to just talk about estate planning. Good to have you here. Anything in particular you'd like us to focus on?
Not necessarily.
Okay, we'll talk about estate planning and then the probate process. I'm gonna try to do it in an hour. I'll try not to speed read or talk too fast. Anyway, estate planning, we don't want your will to look like this. This is the will that was submitted to court. We whited out the name and the witnesses, but anyway, left everything to his wife. On the right there, I think he had his list. He might have been going to Costco, what he's going to buy, but he did his will on the left on the same sheet of paper. We don't want yours to look like that. So make sure we go to an attorney and get a will done. But a will has to have in writing, it has to be in writing, signed by 2 individuals, witnessed by 2 disinterested witnesses. You can also have a notary that makes it self-proving. It does the test to make a will or any of these estate planning documents is generally a 3-part test. You have to know the objects of your affection, know then who you want to leave it to, and generally know what assets you own. And you can do it through a will, or you can do it through non-probate transfers, such as a joint account with right of survivorship, or where you have a beneficiary designation. Anyway, let's consider the documents you should have, and it would be these 10 documents. First, an attorney will give you an estate planning checklist. Very important to look at your source documents. Many times we think we own an account or real estate a certain way, and it may be a different way. For the longest time, real estate was held by husband and wife as tenants in common. It's now primarily held joint with right of survivorship, which means when someone passes, the other surviving joint tenant takes. And it's a basically a will substitute. There's no right or wrong way to do it. It's whatever your intentions are. The attorney's duty is to get that, make sure that accomplishes it. So you can do it through will substitutes, or you can do it through a will. And basically, you just want to have a roadmap of how you're going to do it. I can take the interstate up to Charlotte, or I can go some back roads, but there's different ways to do it. The first is that last will and testament with a trust. Most South Carolinians are fine putting a trust inside a will called a testamentary trust, or you can have it separate, and that's number 6 there, which is a revocable living trust. If you own property in a number of different counties or states, where privacy is your main concern, you can do a revocable living trust. It can be more expensive because you administratively have to transfer all your assets into the trust name. And even if you do a revocable living trust, put all your assets in there, it's always advisable, and your attorney will have you do what's called a pour-over will to capture anything that you have not already put in the will. And that's very important to do that also. But anyway, in talking about trust, this is to protect someone from themselves. Generally, we consider it like, say, for a minor. If you don't have a will and die intestate, and property or assets go to a minor, then the minor has a right to the assets when they turn the age of 18. And most minors can't handle it at age 18. And so what we recommend is to put it in a trust, give them 1/3 at 25, say 1/3 at 30, and 1/3 at 35. And then also have invasion powers in there if they have medical issues, or if they need money to further their education. But that's what we generally see. We did have one trust where the child couldn't get the money until age 65. I thought that was a little restrictive, but like the parents wanted to make sure that they were protected. And at 65, they thought the child would then be getting Social Security fees. So there's different ways to do it. Anyway, the last will and testament, you can also name the fiduciary, which is called a personal representative. Used to be called executor, executrix. In anything you do in a will, or mostly in any of these documents, you also want to have alternate fiduciaries and alternate takers, because you never know who's going to die first. And so make sure you have alternates down. And in the will, you will go through and you will list who's going to get what property. And then you also want to make sure you have what's called a residue or residuary clause that captures everything that you haven't specifically devised. The other thing in the will that we sent out to you, I think in item 2 or 3, you'll see on there a ability to refer to a written memorandum for personal property. So for jewelry, for golf clubs, for fishing rods, you can create a separate list and refer to that from your will. This way, you don't have to go back to the attorney each time to revise the will. You can just revise your memorandum. But the memorandum, remember, only applies to personal property. It does not apply to real estate or cash or bank accounts. So again, when you're looking at your estate planning, you have what's called probate assets, those controlled by the will. And then you have non-probate assets, those that are controlled by third-party contracts. And you've got to decide what suits your family situation the best and what's going to accomplish your goal. And that's the goal of the attorney, is to carry out your wishes legally through the paperwork. So again, probate assets are those controlled by the will. Non-probate are controlled by a third-party contract, or if you die without a will, by the intestacy statute. The third document that I've mentioned is the financial business durable power of attorney. This allows you to name an agent to pay your bills. It's called an attorney, in fact, but it's actually a layperson. So I can name my wife as my agent, and then she can pay the bills if I'm incapacitated. The beauty of this is that you avoid that conservatorship and you save your family some money, because to come down to court, generally have an attorney bring the action for the conservatorship. By law, we have to appoint an attorney for the alleged incapacitated individual. And then we also have to appoint a designated examiner. Generally, you can see how that's going to run you some money. It's easier to get that business power of attorney. But be careful. The business power of attorney are not regulated. So no one's watching over it. You got to pick somebody that you trust as your agent. And then you can put in the powers that you want that person to have. One power that you may not give them or that you might want to consider whether you give it to them or not, is the power to make gifts. You may want to have the power to continue whatever gifting program you have, but otherwise you may not want to have them make gifts or be tempted to make gifts to themselves or others. So just consider that. The business durable power of attorney, to be effective, has to be recorded at the Register of Deeds office. It's the only document that has to be recorded prior to you passing, and that's the business power of attorney. It's called durable because under strict agency law, if I became incapacitated, then as the principal, my wife being the agent, she could not act for me because the principal is incapacitated. That changes, and that's really what we want when we want the agent to act, is if we become incapacitated. So by law, all powers of attorney are now considered durable, meaning the agent can act if the principal becomes incapacitated. Another document it considers is healthcare power of attorney. Very important to have this. Like the business power of attorney handling financial transactions, the healthcare allows you to make and appoint an agent to make the healthcare medical decisions for you. It does not have to be recorded. Generally, you give it to your doctor and to the hospital when you check in. It's the same document for everybody in the state of South Carolina. So the beauty of that, it's a form document, and it's a form document. This allows our head of healthcare and medical care providers to see the same document each time. But the document, to have a document like that, then you want to have flexibility. You'll see that it has the power for maximum healthcare or medical attention. You can put it in your own words. You can withdraw treatment. So the document has great flexibility, even though it's a form document. Just like that document, the Declaration of Desire for Natural Death, also known as a living will, is a form document, and it allows you to state your wishes at end of life. Do you want to be kept alive by heroic means? Again, two doctors have to sign off on that. The document does have flexibility to have you appoint somebody to enforce it or somebody to revoke it. The beauty of the document, though, is it takes that burden off your family when we get to the end of life. And what do we consider? Do we want to be kept alive on all the different machines? We've seen the cases around the country from Terry Schiavo to Nancy Cruzan, Karen N. Quinlan. There's a lot of these cases have gone back, and it's a tough decision, but it's a very important decision that you make, and it helps your family just like it helps you have your wishes carried out. Again, it's nicknamed a living will. It gets confused with the living trust. The living trust deals with property. The living will deals with this Declaration of Desire for Natural Death. I touched on a revocable living trust. This allows you to manage your property during life and then act as a will substitute at death. And again, it's very beneficial if you own property of a number of different counties or a number of different states and you want to avoid probate. Most South Carolinians are fine putting a trust inside a will, as the probate fee is only $95 on the first $100,000 of probate assets. So that's something you need to consider, and I'd have you consult your attorney. Another important document is the 5 Wishes. It's a national document, and you can Google 5 Wishes and you can download it. It's a nonprofit out of Florida that is trying to get America to talk about the one thing we don't talk about, that is a certainty, and that is death and dying. And this allows you to put in writing how you want to be treated at the end of life. And it goes through those 5 wishes, what you want your loved ones to think of. You can choose cremation in there. It's sort of a combination living will, healthcare, power of attorney. Again, the 5 wishes is recognized here in South Carolina and in most states. The DNR, the do not resuscitate order, generally was when you're in the hospital. I lost a brother a couple of years ago to cancer. He knew the cancer was going to take his life. He executed a DNR in case he had a heart attack when he knew he was going to pass in just a matter of days. So he could go ahead and pass without having to suffer and battle any further. Along the same lines, over at Roper St. Francis in the cancer unit, there's this physician's order for life-sustaining treatment called a pulse. Some states will call it a MOLS or a post, but it allows you to also make those wishes. And it's a combination: healthcare power of attorney, living will, 5 wishes, and DNR all in one. Again, important life decisions made at our end of our life, and whatever you decide is the right answer. But it helps your family if you make that call. I'm one of 10 kids, and my mom, when she executed this, had one sister very emotional. She wouldn't put that burden on her. She put it on someone else to make those decisions. And you've got to decide in your family who can best carry out your wishes. Let's talk about organ donation, which you can do in your healthcare power of attorney. And I'll show you a nonprofit here, which also is handling that. And safe cremation law. It was recently passed. More and more people are choosing cremation. It's probably about 70% of the business for funeral homes today, but we do have safe cremation law. Remember Michael Jordan's dad, James Jordan, was killed in North Carolina, body dumped in a rural county in South Carolina. They didn't have the means to keep him. They took a dental impression and cremated his body, and realized weeks later it was Michael Jordan's dad. So many states, our state included, passed a safe cremation law where you need to get with your funeral home director, do a pre-need authorization, or put it in your will, or all your family needs to agree after you pass. Again, cremation is probably about 1/3. Well, it's probably 2/3 of the business now, 2/3 to 70% for homes. Yeah. Did I have a question? And anytime you have a question, just put it in the chat or just open up your mic and stop me.
I just have a real quick question.
Sure.
Jamie sent out a lot of documents.
Yes.
Is this list included?
The list may not be, but we can send that out. That's a good question, Jamie. I mean, good
Appreciate
question, sir. Yeah, we'll go ahead and include that, Isaiah. Jamie, so that list of 11, yeah, we'll go ahead and send that out, but we'll go ahead and include that each time in the future.
Yes, sir.
That's a good question and a good suggestion. Y'all need a good joke for today or not? Uh-oh.
I know.
Go back. Tell me if y'all like this or not. You got ran over by a steamroller.
Oh my God.
Okay. Tell me if we should keep that or not, or give it a thumbs up or thumbs down. Try to get everybody to smile a little bit. There we go. Good, good. If you want to help others and don't have the money to do your own foundation or get it qualified with the tax commission, you can simply go to a community foundation. We're blessed here with Coastal Community Foundation here, and it allows us to, it allows any family member to set up their own charitable giving without involving administrative costs. We had a devise here of about $50,000 to help Charleston County residents go to high school. They looked at doing their own nonprofit, their own foundation. By the time they did all that, they were going to use up most of the $50,000. They could simply go to the community foundation and get it set up. We also are blessed with the Center for Heirs Property. They help our heirs get clear title. They're now located up in North Charleston on Rivers Avenue at the Opportunity Zone. They also have wills clinics. and also Reverend Clemente Pinckney was instrumental in getting that right of first refusal so that heirs have a right to buy the property before another heir sells it to a developer. If you're looking to get an attorney, one free service is this Martindale Hubble, where you can look up attorneys, look at their peer rating, look at their location, look at their academic background. A good way to choose an attorney, better than selecting it off the TV. If you can't afford an attorney, we got Charleston Pro Bono. They very much can help. South Carolina Legal Services also helps. In between is sort of the Charleston Legal Access. They charge on a sliding scale. Organ donation, I mentioned that earlier. Dr. McManus started this Gift for Life. You can register there to be an organ donor. Elder law, I'll just touch on this briefly. Everyone's considering elder law. I would highlight the issues that you run across, Medicare versus Medicaid. It's advisable always to get somebody that can help you with these issues, the different options that are available, and for Medicare or Medicaid, that you might qualify. The Palo Alto Project is a good source of information, so we always recommend them. They're very knowledgeable in this area. And their part are also the Trident Area Agency on Aging. They can give you help to many of the senior issues you may have. And they located up in North Charleston, very good group that can help you. And we also recommend everybody take a ski vacation. Any skiers here? Skiers?
No.
Skiers? Okay. You can still take a ski vacation. That is, spend the kids' inheritance. So you never know when we're going to get when God's going to call us. It may not be taking a trip. It may be helping others. Maybe you've got somebody getting married or they need help with their car or with their home. So go ahead and do it while you're alive so that you can enjoy it while you're alive. The other thing you can do, if your kids don't treat you well enough, you can leave it to your pet. South Carolina recognizes a pet trust. And we had 2 dogs here. They got $900,000 in trust. Couldn't be kept outside on a chain. Any surgery down to Auburn University. I guess one of the better vet schools there. And then when the dogs passed, they went to the SPCA. And then we had another dog out on Kiowa Island that got a home. So I'm not sure if they love their pet or if the kids were bad to them and they just decided to give it to the dog or their cat. So tell your kids and grandkids, if it's not nice to you, you're going to leave it to the dog or the cat. Okay. Now let's talk briefly about wills, probate, and estate administration. In South Carolina, many of you may be facing this. We've got 3 ways to probate an estate. The first is under $25,000 and no real estate. It's a summary proceeding. You open and close the estate 30 days after a person has passed. We'd want a paid funeral bill. You'll fill out an application. You'll sign an affidavit that all the creditors have paid. That's the summary proceeding. Most of our estates are under this normal administration. It's one where we've got a version of the Uniform Probate Code where you give notice to interested persons. If no one objects, then it's open and closed 30 days after a person's passed. No, it's if no one objects after the 9 or 10 months, then it's closed. The creditor's period is 8 months. Some states are 4. Some states are 12 months. Our state legislature chose 8 months. So that's the publication you see in the newspaper. So a creditor has 8 months to come forward. Interested persons are those that would take under the will called devisees, or those that would take, if there wasn't a will, called heirs, and then also the creditors. If no one objects, after you do the administration, then the estate is closed administratively. Our contested cases are fewer cases, but we have notice and hearing each step of the way. You can actually start with a summary proceeding, realize you have real estate, go to normal administration, and then from normal administration it could be contested. So you can go from one to the other. And we'll talk more on this. I've got a whole slide on each of the individual documents on normal administration. Then and now, you can now do it in person by e-filing. It used to be in person only, but we do have e-filing. There's a one-time $7 charge that goes to our Atlanta-based computer company for this easy filing. But you save the cost of driving downtown and parking, and I think you'll find it very helpful. And we're getting ready to set up. If you don't have the technology of a computer and scanner at home, we're setting it up at our libraries and our senior centers, because our county runs all the way up from McClellanville down to Edisto. So we have a very long county. And our easy filing program is the first in the state, and applies not only to lawyers, but to the general public. We're now open 24/7. And as indicated there, we'll use the libraries and senior centers. And then for our marriage license, we have a electronic program called Love, which is live online virtually marriage application. So you can apply online, not have to make the trek down here. Let's talk briefly on trusts and estates. What are we seeing at the court? We lost the Charleston 9. I went to school with Billy and Randy Hutchinson. These firefighters, like most first responders, considered it bad luck to get a will done. And so we're trying to change that, make sure everybody gets their will done. They're the ones running into the burning building we're running out. They definitely need a will. So trying to change that, that thought process there. We lost the Emmanuel 9. They showed us that love conquers hate. They had no violence in Charleston after that. In the middle there, you'll see Reverend Clemente Pinckney was instrumental in getting the right of first refusal passed. And President Obama, they're speaking at the College of Charleston at the memorial service. I did a workshop, a state workshop for the families at the library about 10 days after this incident, just trying to help them through that probate process, like I'm trying to help you today. Football, we just had the draft. Clay Matthews was had to have his trust revised, reformed. He grew up here in Charleston, was actually boxing coach at the Citadel, and a lot of family that played in the NFL. Henry Pickard won the Masters, had a will interpretation case that we did here. And Sheila Joe Jackson signed not many documents. One that he signed was his will. He wanted the charity that was a residuary beneficiary sued the court to get the original will, because to a baseball collector is worth about $75,000. But the Supreme Court said if you file any document with the court, it stays with the court. So if you're famous and file your will with us, it'll stay with the court. The Countess that started Spoleto used a local attorney, and she is still benefiting our community, and Spoleto is about to come up. You can name your living trust anything. Over in Aiken, James Brown named his the I Feel Good Trust. So you can decide what you're going to name your living trust if you do it that way, or your testamentary trust. Marriage licenses, I'll talk briefly on this. We do about 5,000 of these a year. We have this Love program, the live online virtually marriage applications. If you have any family that needs to, anywhere in the state, needs a marriage license, they can simply go online. There's a 24-hour waiting period by the state legislature. Who's coming through? Dr. Gupta that you see on CNN. They've come through, movie stars that have come through and gotten their marriage. Charleston's a wedding destination. And you'll see some of those. Let me talk briefly about civil commitment. Mental illness affects all of our family members. We'll know somebody that is suffering, that needs help. And also alcohol and drugs, a big issue. Probate court is here to help. We have jurisdiction over involuntary commitments. It's a civil process. It's not a criminal process, just a process where hopefully people get the help that they need. We hold hearings now virtually at MUSC through the Institute of Psychiatry, at Palmetto Behavioral up in North Charleston, and at Ralph Johnson here, our local VA center. Some cases that have come through. Some of these high profile cases, Alice Bowen, we almost had a Sandy Hook here. She had a gun and fortunately it jammed while all the girls were in line. They're getting ready to go home. Centers for Mental Health. We got the Institute of Psychiatry, Palmetto and Charleston, Dorchester Mental Health Center. The Alcohol and Drugs, a separate unit under the Department of Alcohol and Other Drug Services, the Charleston Center, and they're getting ready to relocate up in Rivers Avenue. We're blessed with the VA Center named after a Charleston private, Ralph Johnson. He jumped on a grenade in Foxhole over in Vietnam, saving several comrades. Involuntary commitment process, one thing you need to know is that we do have this blessed with mobile crisis. They will call a judge if somebody is a danger to self or others, and we can take them to a hospital to get the person evaluated. When I do trainings, I go through the different paperwork, a little bit much for today. You do need to know that there's due process there. We appointed an attorney, guardian ad litem for the individual. There's 2 designated examiners, a judge, there's a hearing, and we try to get them the least restrictive setting to get them the treatment they need. I've started 4 problem-solving courts to help our community. A drug court, I went down to Miami. And Judge Goldstein actually came up here to help us start our court. He was a Brooklyn cop turned lawyer turned judge. I'm just trying to give people a second chance is what drug court's about. Similarly, mental health court. We want those suffering from mental illness, not in our jails, but out in the community, getting the help they need. Also our veterans, particularly those with PTSD. We work with the VA center there to get people the help they need. Judge Russell, who was not a veteran, started the first veteran court up in Buffalo. And people in our drug court and veterans court, not always the smartest. Guess what house Brian broke into? One of the requirements of these programs is you have to pay restitution back. Here's Brian paying restitution back to Chief Mullen. When you're high on drugs, you'll break into any house. I don't know how he picked the chief's house, but he ended up there. Fortunately, the chief wasn't home and Brian's still alive. So he paid his restitution back. On the far left there, you'll see Judge Hendricks joined us that day. She has started a federal drug court across the street. We also are piloting a couple programs. One is our visitor guardianship program. Our county in Phoenix, we're proud to say we're selected. And I go to the law school and train students to go check on our wards to make sure the wards are okay. Along with that, the National Center for State Courts selected our court for this conservatorship, this rapid response conservatorship project, basically monitoring expenditures in real time. Ours in Detroit were selected. These are our online services you'll see. And we put the estate administration workshop. If you ever want to watch a workshop, you'll see it down there on the bottom left that you can watch. If you can't sleep at 10 o'clock at night, you can turn me on and take a look. And again, we're open 24/7 and we're here to help you in any way. You can still file with paper or you can file online in our GC and in our state area. We give free workshops like this, and we're getting back out in the community. Question? Yeah. Here are my ski trips. St. Andrews, my son loves basketball, Harlem Globetrotters. We went to Fenway Park to see the Red Sox, and the Braves were playing. So I'm a Braves fan too. And this past summer, we went out to Oregon, couldn't travel too far, but we stayed in the lower 48. My wife there is in the middle. Can you tell what's behind her? It's one of the top 10 attractions in Seattle of all things.
Can't tell.
It's called Gum Alley. You can believe that. That's gum on the wall. She was like, yeah. But it's below the beautiful flowers on the left, which is down there in the Seattle market. We made it to the Olympic trials. Up there on the top right is Anna Cockrell, who's from Charlotte. Where's my Charlotte person here? Okay. She runs for Southern Cal. There you are. She played, her sister played volleyball with my niece at Davidson, but she won. She's doing the fight on there. I've never seen so people people so happy to finish third in any race. Why was she happy to finish third? It's the Olympic trials. I think she was happy. If you finish third or higher, you're going to the Olympics. So she was going to the Olympics.
Yes.
She came back at the end to finish third, and she went to Tokyo, which is an amazing. Let's talk about the probate process. We talked earlier about the three ways: the summary proceeding, the normal administration, and now we got a sample estate file, and we'll walk through the normal administration. The third way was the contested way. And we've got an estate index, and we're working on getting a better copy of this, but you'll see we've got a description of the various items on the left. We have a date, and then we have an index number. And so when you go through the probate process, we would start at the bottom with the death certificate and go all the way down to certificate of discharge. The goal in the probate process under the Uniform Probate Code is to give everyone notice and who are interested persons. And interested persons, again, are those that take under the will called devisees, or those that would take if there's not a will called heirs. And then also our creditors. We give all those people notice. If no one objects, in most of our states, no one objects, it goes through administratively. Just remember the probate practice in South Carolina is very much a form-driven practice. There's a form for everything. So if you're looking for something, there'll be a form. And we do start with the death certificate. We have to have some proof of death. Years ago, when I started off, I think we accepted newspaper articles or just obituaries. Well, lo and behold, the laws are always written not for those that obey them, but for those that disobey them. Somebody said they were offshore, fell overboard. They needed to open the estate to collect $1 million life insurance policy. The FBI got involved, and lo and behold, they located them alive down in Beaufort County. So you can't fake your death. We have to have a death certificate. In that case, say if you fell overboard, we have to have a hearing and proof that death did occur. We lost a plane off the coast here last year, small plane, didn't find anybody. They did find an oil spill, and they had a report from the Coast Guard, and then also a report from the FAA. So if you die in an accident, that can be proved by testimony. If they don't have a body, we also lost 2 boys out at Folly Beach. They found the body of one, not the other. And so we'll take testimony to prove death. Or if you're missing for a period of time, you can be proved deceased. We had a Charleston resident hop on a plane, went to Atlantic City, was never found, just one of those unsolved murders. The family came in after the period of time. It used to be 7 years. It's now 5 years if you're missing. The testimony was that, yeah, every Mother's Day, any birthday, Christmas, any anniversary, he would send a card or a gift and had been heard from in that period of time. So after that period of time, he can be declared deceased. So we do need some type of proof of death. If you lose a loved one from suicide or some other death you don't want disclosed, we'll simply take the top part of the death certificate there. Again, if you die with a will, it's called dying testate. Without a will, it's called intestacy. Any of the documents we pass out, again, remember, don't use those, go to an attorney. Here's an example of a will. And if you look at item 3 there, you'll see that a mandatory memorandum that I was referring to, which basically, I know it's hard to read there, but says I may have a memorandum where I'm leaving my personal property. And you'll see the different devises, the naming of the personal representative, the powers, how you're going to pay your personal representative. Item 9 down there is the powers of the PR, and so on and so forth. And here's a trust. Item 10. Jamie, we'll need to get a better example because that says age 21. I'm a believer in the 25, 30, and 35 as far as giving a trust to someone. And there are different definitions in there. And you'll see the two witnesses and also the notary. The probate process, again, is started by delivering the will to the court, if there is a will, providing a death certificate, and then also filling out an application like you see here. And the application, as I said, has all these forms have flexibility. So you'll see different options you can check. In the case here, it's called informal probate, so it'll be an application. If it was a formal action, it would be a petition. And one thing that I want to highlight, we've been talking about interested persons. 4A is a good example of that. We've got people named in the will called devisees. 4B is those that would take if there wasn't a will. So in my example, I've got dad passing, survived by mom and 4 kids. Under the will, 2 of the kids take, so they're under 4A as devisees, and 2 do not take. They're under 4B. The ones in 4B also have to be given notice because arguably, if they thought something was up with the will, they could contest it. Generally, there's nothing up with any of these wills, but it's just a requirement to give interested persons notice, and they can be spread all across the country, all across the world. They may not know someone has passed. And we'll ask you about the will. These are different things that you'll check going through. You deliver the original to the court. We will then put a scanned copy in the file, and we store the original at a record center up in North Charleston. You'll sign a verification. If you notice down in Gail's from Charlotte, she would have signed that verification, and she would have submitted to the jurisdiction of the court here in South Carolina, even though she's in North Carolina. So under verification, you'll see that. The judge, after everything is done, will sign the order for informal probate and informal appointment. You'll be sworn into the office of executor or executrix. It's now called personal representative. Okay, I only got one on with the camera. Gail, you're my only example here today. Raise your right hand. Let me see if I got to see your right hand. Okay. All right, good. Good. You can put it down. Gail is honest. Gail is honest. She does not have a mark in the palm of her right hand. Tradition had it, if you're dishonest, that red hot poker and mark your right hand. So Gail is honest. We're good. I did have a case one day where a guy took a stand. He had a mark in the palm of his right hand. I had to ask him about it. It had a construction accident. Gail is good though. Okay, we got, after you open the estate, we'll give you 2 receipts, one to open the estate, the other for publication. You'll select the newspaper. Any of these newspapers are good. It needs to be a newspaper of general circulation in the county. It's published once a week for 3 weeks. Yeah. Yes, we can do it online, but the lobbying group from the newspapers is blocking it. So we still got to do this publication. And you can choose which newspaper best suits you. Fiduciary bond, basically an insurance policy that the personal representative will do the job they're supposed to do. Generally not required unless you've got a personal representative you're not sure that you trust. So then you can ask for the bond. The bond is calculated on 1.5 times the value of the personal estate. Does not include the real estate unless the real estate is sold. Here's another document that shows great flexibility. It's a renunciation of right to administer and nominate or waive bond. So if you're named as the PR and you can't serve, or you think somebody else better could serve, you can renounce your right. You can nominate someone else. Of course, you can't skip the named person in the will, but you can always, you can nominate someone else, and we'll see how that sorts out. You can also waive bond. Many times in our intestate estates, a surviving spouse is priority, and they'll have the kids waive the bond so that mom or dad can probate the estate without incurring that cost. Anyway, what you need to take from all this, there's great flexibility in the probate code, maybe to accomplish what you need to do for your fact situation. Once you're appointed, you'll give a certificate of appointment. This is what you can take to the bank to show that you are in charge of the estate by the office of the personal representative. Think of the estate as a separate business, corporation, partnership. and the person in charge is called the personal representative. You're also given fiduciary letters, and this will indicate that you're the person in charge of that. Your banks, your brokerage firms, they may need copies of these. Information to heirs and devisees. We talked about the heirs, those who take what is not a will, and devisees, those named in a will. This is how you give them notice. You'll send out this form. So once you're appointed, you have 30 days to send out the information to heirs and devisees. And you'll let the court know that you've done that through a proof of delivery, which is another term for basically an affidavit. So you're letting the court know, here, mom has given this document by mail to the 4 kids. Let them know that the process has started. 90 days after your appointment, another benchmark, 90 days, is that you must file an inventory and appraisement. And even though I've got both probate and non-probate property listed here, you only have to list the probate assets. But I guess the point I was trying to make with this example is that many times the non-probate assets far exceed the probate assets. And you've got a recap here of the supporting schedules that'll go behind it. You would also sign it as the PR. If you look up at the top there, this is the original. If you find assets later on after you filed your original, you can amend it to add the other assets. I didn't want to make this a tax class, but if we look on page 25, the one thing that we all need to remember, the one time the federal government is good to us is at death, and they give us what's called a step up in basis. And so let me try to explain that. If I bought a piece of property 30 years ago for $10,000, I wish I would have, because everything in Charleston's gone way up, it would now be worth, say, $100,000. So if I sold it today for the $100,000, my basis is what I paid for it, which was the 10. I would have a $90,000 income tax gain. Everybody follow me there? Okay. If I die and my wife sells it a day after I die for the $100,000, she would get a step up in basis to the fair market value at my date of death, which was the $100,000. So she would have no gain. She'd sell it for 100 and deduct my 100. So many times, one thing just to highlight is sometimes it's good for property to go through a person's estate. They get a step up in basis. It's the one time in the taxing system that the federal government is good to you. So just remember that. Anyway, Schedule A, we list the real estate. This is individually owned, or if it's owned with a spouse as tenants in common, it would be listed here. Schedule B is stocks and bonds. You would pull that off of the brokerage statement. Schedule C is cash. Life insurance, generally a non-probate asset, can be a probate asset, depending on who you name the beneficiary. Schedule E, this is optional, and this could be the property that's joint with right of survivorship. Other miscellaneous assets, just a ballpark figure generally fits there. Unless you've got a dispute, then you want to go ahead and video and take a picture of all the assets if there's going to be dispute. But if it's just brother or sister or 2 sisters, if you can just agree among yourselves. And then you'll see some other transfers during the decedent's life. We get a revocable trust there, payable on death account. Power of appointment, a sophisticated tool where somebody in a previous will now gives you the power in your will to designate a beneficiary. Retirement accounts, so they're generally a non-probate asset unless you name your beneficiary as the beneficiary is your estate. Encumbrances, you'll see that there. Generally, we list here only encumbrances to property that we list on the inventory. This does not include the unsecured assets such as credit card debt, just the secured debt there. You'll get a bill from us. It does not go to me, it goes to the county coffers. It's generally $95 on the first $100,000 of assets. And you'll get a receipt from us once it's paid. Here's the publication in the newspaper. You'll see that it's published once a week for 3 consecutive weeks. And it starts running from the first publication is when the creditor's period begins. If you've got a creditor's claim, they would file it on this form. or a form like this. It could be any color. We use different colors, but any color works. The statement of a creditor's claim. If you're the PR, there's a couple of ways you can handle it. Show that it's been paid, or maybe you pay part of it, you compromise it, or you can send a notice of disallowance. Notice of allowance or disallowance is sent by you, the PR. On the other hand, the creditor could actually petition for allowance of the claim, or they could wait to the end. And here's an order for petition, maybe allowing the claim. Deed of distribution, this is the way that you give up your interest in the property as the PR. The property devolves at death to the others, but it's subject to the provision that the PR can move it into the estate if they need to pay claims. So you'll file a deed of distribution with the Register of Deeds office. This is an example of one. It's considered practicing law, so our estate clerks can't draft this for you. You have to do it yourself or use an attorney, which is advisable. And that's filed at the Register of Deeds office. We get ready to close the estate. If you're the sole heir, sole devotee, you can do a verified statement, which basically says, I've done everything I'm supposed to do and I've paid the creditors. Most of our estates, there's others involved, and you'll file what's called closing documents, showing the work that you did during the estate administration. The first would be this accounting, and you'd give detail on what you spent and how you spent it. You would also do a proposal for distribution. I haven't distributed everything. These are my plans. If you did distribute something, you'd have them sign a receipt, and hopefully they'd sign a receipt with a release with waiver, which has that language in there that you're not going to hold the PR responsible. Many recipients are leery about signing that. They're more comfortable signing just a receipt. And then another flexibility of the code, if your family members can want to waive receiving all the closing documents, they simply can do that. But generally, you'll send the closing documents. Very important when it's this notice of right to demand a hearing. So you're going to send them all the closing documents, the accounting, proposal for distribution, and this notice of right to demand a hearing. Basically, you're saying, I've done my work as the PR. Here it all is. If you have any objections, then you have 30 days to demand a hearing. Sometimes people do. They want more explanation. Most of the times, no one challenges it, and it goes through. And also, when you file that with the court, you'll file an application for settlement, asking the estate to settle, asking the probate court to settle the case or to close the case. And you'll give us a proof of delivery that you set the closing documents. In this case here, you'll see that it narrowed. It just went to the takers, which were the two kids named in the will, not the two kids that would have taken if there wasn't the intestacy statute, if the intestacy statute applied. And then we'll give you an order closing the estate. And that would be it. We just want to remember your estate planning and the ski vacation. On the probate process, if you close the estate, you get an order closing the estate. If you later find another asset, you can do something called subsequent administration, and you can reopen the estate. How they came up with it, but the fee is $22.50. But that's to reopen the estate. It does not reopen the creditor's claim period, and there's special forms for probating the that subsequent administration. I would also say if you get behind on filing something, we're here to help you. So go ahead and send us a letter or an email, something in writing indicating you need more time. We also have the more formal motion for an extension of time. Yeah, we generally will grant those if you need more time. So just let us know how we can help you. That's a quick run through on estate planning and the probate process. If you've got questions, I'm here available to take any questions. Or if you've got a run and you want to call or email me, my direct dial number is there, also my cell number, and also my email address. We're here to help and try to make what is an unpleasant situation as best we can pleasant. First estate I did was my dad's when I was in law school and had an attorney help me there. And then recently I just did my mom about a little over 2 years ago. So I know it's difficult dealing with the loss of a loved one and dealing with paperwork that brings up the memories back, but we are here to help you. Someone's got to have some questions or comments. How can we help you?
I don't have any. I'm good.
Okay, good.
I
Thank you
do.
for joining us today.
Thank you
Judge
for
Condon.
having,
I do. I have a question.
Sure, sure.
So if, for example, with me, I was paying my mother's bills long before she passed. When my father passed, and of course his estate was closed. I have all of that paperwork. My mom and I set up a joint account, and I paid all of her bills and did all of her finances for her. So of course, when she passed, we still have the joint account, which I pay all of her bills from.
Okay.
What happens in that case, which of course I have to pay everything that she has left, which thank God was very little to pay off. But what happens in that case with the funds that are in her bank account? They're also, it was a joint account between the two of us. How does the court look at that?
Okay. Generally, by operation of law, when someone passes and there's a joint account with right of survivorship, the surviving joint tenant is entitled to those.
Okay.
But if the family agreement is that we're going to split everything, then you'd split that with the other family members. But technically, by the law, it's all to the surviving joint tenant. And that's why we would advise, we talked earlier about that business power of attorney. Say if dad had a will and he wanted to leave it to his 5 kids, but he had local child on the account. If it's joint with right of survivorship, then local child's entitled to all of it, subject to if there's any type of agreement that they had or just in good kindness that they all agreed that it was going to be split with all the siblings. The way we would correct that is we'd have dad put the son, the local son on there as the agent under the business power of attorney. So when the business power, when you pass, the power of attorney ceases, and then that individual account is in dad's estate. So that's generally how that works there. Yeah.
Okay. All right. Also, with my mom, she had a vehicle, and my sister and I had a conversation. We did not want to sell the vehicle, but I told my sister that I wanted to be able to keep something of my mom's, so that the agreement would be that I would pay her for my portion of what the vehicle would be worth. That is something that's okay if we both agree upon it?
Yes, and then you highlight something I did mention is that the probate code has what's called a private family settlement agreement, where family members can agree among themselves who's going to get what out of the estate and when. And so that private family settlement agreement, the code section is 62-3-912, 62-312. And in there, you can do a private family settlement agreement. Basically, you can rewrite mom or dad's will. And as long as all the interested persons agree, then you can do it that way.
Okay, all right. And you already told me about the furniture and all that stuff, so I appreciate that very much.
Y'all just agree among yourselves and
Yeah.
and do receipts, and if you want. But if you got a good family situation, there's no issues.
Yeah,
I mean, it's a lot easier. Yeah.
it's gonna be very easy. Thank God it was just the two of us, my sister and I, and my mom communicated with both of us all the time, and my sister and I are in total agreement. So
Okay, that's good.
yeah.
And the other thing
Yeah.
we try to tell families, particularly with photos and paintings, the technology has improved so much that you can almost, well, you can get a replica and it almost looks better than the original. So
Yes.
if somebody doesn't want to part with a picture or painting, you can somehow get it replicated.
Yeah, share.
and share, right.
You're absolutely right. This was extremely helpful.
Oh,
Judge Condon.
good,
Thank
good.
you
Thank you.
so
You're
much.
welcome.